uses that money, his receivables are inflated because those accounts remain owing. And then when they get to be due, April Hamilton knows that now it's time to pay off those accounts by running the money through Kosher Community Grocery and Torah Education at times. There's a ton of additional criminal activity that just wasn't accounted for in a mere guideline calculation. And then there's all the things the defendant did wrong during the investigation and the trial. There's destroying evidence, both computer and paper. There's committing bank fraud while on pretrial release. And there's perjuring himself at trial. These are all things that the court appropriately took into account in getting that 27-year sentence. So if you ask, how do you get to a 27-year sentence in this case? That's an awful lot, especially considering that the guidelines call for one.
Well, one of the things that drove this was the loss calculation. You might want to explain a little bit about the losses.
Absolutely. First of all, the guidelines say that the court's to make a reasonable estimate of what the loss is, and this certainly was reasonable in this case. The defendant relies primarily upon intended loss cases, where there either was a smaller actual loss or no actual loss. And the court was looking for a way to calculate the loss. It said, okay, well, we'll use the amount of fake collateral that was out there. In this case, the actual loss was higher. It was between $26 and $27 million. Now, in addition to blurring that distinction between actual and intended loss, the other thing the court has to remember is there were other fraudulent schemes here.
Explain how that was an actual loss if he was paying the bills and he had that loan anyway.
Right.
Was that because of the bankruptcy? That's what they were out?
At the end of the bankruptcy, they were out a lot more, actually, because they continued to put what's called dip financing into the company and what have you. But this was the principal balance on the revolving loan. And why was it all attributable to the defendant's fraud? Because this wasn't just about receivables, okay? But the receivables themselves caused the business as a going concern to be worth dramatically less at auction. So the bank loans to the company, thinking that they're complying with the law, and that.
But did you put on evidence that if the truth be known, this company would be worth X, and not knowing the truth, they thought it was worth 3X, and the difference is $27 million?
I don't know if it was a precise calculation like that. Part of the reason because of the fraudulent accounting, it was difficult to determine exactly what was happening and what the company was worth. But the attorney for the trustee testified at the sentencing and said that, there were all these claims that this company is worth $40 million. And people were saying, yeah, I'm interested in buying. And then they did their due diligence. And they discovered that the defendant had been creating fake invoices and not reporting received customer cash. Again, that merely to the tune of $12 million, and nobody knew what they were buying. And that meant that the entire business sold for dramatically less. All of that collateral was taken off of the amount of actual loss to arrive at that $26 million figure. The defendant was given credit for everything that the bank got back. It just wasn't enough. The other thing the court has to remember here is there was the...
Let me put it this way. Did the bank lose $27 million on this loan?
Yes. Absolutely. Well, the defendant wants you to factor in all the interest they made over the years, but of course they don't get their money for free. Yeah, they lost. That was the actual loss, the actual principal balance on the loan at the time of sentencing.
Yeah, this revolving line of credit that got up to $30 to $35 million. When all was said and done, your evidence, all I know is what's in the briefs, and This was never quite clear to me. But after all was said and done, out of that $30 to $35 million line of credit, they got back whatever, the $3 to $8 million, and now they're out $27 million.
That's correct.
But of course, that entire amount wasn't attributable to actions related to the fraud, was it?
Yes, it was, and here's why. Number one, the accounts receivable...
And there was a certain amount of money that was loaned to them based on a legitimate assessment of the value of the business.
That's correct. And if you look at the record, there was about 20...
Wouldn't that amount be excluded from the calculation of the loss because it would have been loaned anyway?
For two reasons, no. Number one, because it was about, by the way, it was about 20, if I remember correctly, about $23 million in receivables that the defendant was borrowing against at the time of the bankruptcy. And somewhere around $10 million of that was fake. There's an additional diversion that further inflated the receivables. But again, because the entire business as a going concern, which was something that was important to the bank, because they weren't able to get as much for the business, they weren't able to recover even on the good receivables. Plus, it's a fire sale and nobody wants to pay full value. In the guidelines, there's an application note that says credits against loss. Whatever the value of that additional credit collateral is, gets taken off the loss. That was done in this case. And the other thing the court has to remember is the defendant was convicted of defrauding the bank by lying about harboring and lying about paying his packers and paying his cattle suppliers on time. Those are factors that clearly led to the loss of the entire loan. That's why they were in the loan agreement, that you don't commit crimes that are going to affect the collateral. And there was a specific provision about paying cattle suppliers on time. So, are we supposed to just ignore that aspect of the fraud? No. All of that factored into the principal loss here.
Okay, your time's expired. Judge Murphy, anything? Okay, thank you very much, Mr. Deegan.
Thank you very much.
Ms. Lysenby, how much time is Mr. Lewin now?
4 minutes, Your Honor.
Okay. We'll give you at least 5 minutes.
I thank the court for its generosity. Let me first say I was really very surprised to hear my colleague say that the Lillienberg case in the Supreme Court, and he quoted it, does not on its own authorize the reopening of closed litigation. Yes, that's a quote from Lillienberg. It immediately thereafter, the court says, however, as respondent and the Court of Appeals recognized, Federal Rules of Civil Procedure 60B provide a procedure whereby it is reopened. There's a whole long paragraph in which the court says they can vacate judgments whenever such action is appropriate to accomplish justice. It's just the opposite. There were two issues before the Supreme Court in Lillienberg. One was, what is the standard under 455A? And the court said it is the appearance of partiality. The second issue, and the court explicitly said it was the second issue that they were deciding. Can you reopen closed litigation? And the court says Section 455 doesn't literally say that. And my colleague quoted that. And then it goes on to say, nonetheless, Rule 60B authorizes it. The interest of justice authorizes it. We should reopen closed litigation. So the government is plainly wrong. And I have to say, with great regret, my colleague quote from Lillienberg just misled the court, it seems to me. I'm sorry to say that. With regard to the Santos point, again, I can read to the court what the indictment says. And it says in paragraph 41 that in order to continue to obtain advances from FBBC under the loan agreement and to hide the improper diversion of customer checks, defendant Rubashkin needed to deposit funds into the depository account. Nothing could be clearer than that the government has said that's part of the act, the original criminal act. It is not the use of proceeds. And again, before Santos, Judge Riley, you said in the Fithian case, which is cited at page 76 of our brief, money laundering proceeds are funds obtained from prior separate criminal activity. That's what this court held before Santos. It certainly holds that after Santos. Then, with regard to the question of the judge's participation, if the court goes through what appears in the appendix, I put to the court there are at least 12 meetings. And the question is, if there was just logistical cooperation, why did the U.S. Attorney and the Immigration Service not simply meet with the court's administrative personnel? You can talk to Judge Reade and say, look, we're going to have a lot of arrests. There's going to be a lot of proceedings. And the proper thing for the judge to say, according to the experts in ethics, whose affidavits we think are key in terms of this case, they say deal with the administrative personnel after that. That's fine. It's not the judge's business to say, I want a final game plan. She was pressing the U.S. attorney, according to the immigration documents, for a final game plan with regard to this raid. What business was it of Judge Reade's to know what the final game plan was with regard to the raid? She was, unfortunately, and became, I think it's psychologically, you become part of the team. We support this effort. This is a bad thing that's going on. Immigration is doing a raid. I support it. And she said that, and she said it at a meeting that, according to the immigration documents, she requested that all these other people attend. The immigration documents say that these other people attended at the request of the judge. Why did the judge ask that the immigration officials attend the meeting? We're saying either this is enough to say there's an appearance of partiality, or at the very least, what the court has to do, and in the La Fuente case, I think the court said where there's an attack on the judge, him or herself, there ought to be a hearing at which it's determined. And that is what is involved in this case. Among the worst, the court in its in-bank opinion in Moran versus Clark in 296 F. 3rd said, we find particularly worrisome the district court's failure to disclose the conflict himself. If this was so innocent, Judge Reade should have disclosed it herself, and the prosecutor should have disclosed it to trial counsel. Now, I really can't sit down without telling the court that in my half-century of law practice, which has included a substantial number of arguments in the Supreme Court and in every federal appellate circuit, I have never represented a client who has as much community support and who has, at the same time, been as unjustly maligned as Sholom Rubashkin. The religiously observant Jewish community is very sensitive to conduct that casts it in a bad light, and it is not forgiving of those who violate the law and expose it to shame. But they have rallied behind Mr. Rubashkin because they recognize that in this case an injustice has been done. He's an extraordinarily good man whose principal objective was to provide a service to America's Jews by making the highest quality of kosher meat available across the country. No witness at his trial had a bad opinion of Mr. Rubashkin. All agreed that he was sincere, generous, concerned, a problem solver, trustworthy, honorable, good to his word, well-intentioned, and honest. That all appears in the transcript. We ask this court to reverse the judgment, and again, because we did not want to appear presumptuous. We had asked for bail pending sentencing. We did not want to appear presumptuous because bail was denied at that stage. However, at this point, now that the case is before the court, I will advise the court that we will be filing a motion for bail pending this court's consideration of the merits. And we think that after almost 2 years in jail, in a medium security jail, which he's been assigned to because of the length of his sentence, this court should, at the present time, release Sholom Rubashkin. Thank you, Your Honor.
Thank you, Mr. Milton. Well, thank you all. Very well argued both in the briefs and orally argued today. And we will take it under advisement and be back to you in due course. We do thank you for your presentations. Well done. With that, we'll be in recess until tomorrow morning at 9 a.m.